Welcome to We Learn, Virtual Learning Network. This is session number 11, Executives. Topics which we are going to cover in this session are President of India, Powers of President, the Prime Minister, the Cabinet and the Parliament, the President and the Prime Minister. Coming towards the first topic, that is President of India. The Constitution has made detailed provision to see that the President, the head of the state, is a ceremonial head and that he did not arrogate to himself any real power. The President is indirectly elected from term of 5 years and can be removed on the basis of impeachment proceeding brought against him by the Parliament. The Constitution also provides for the post of a Vice President who would serve as head of the state in the event of President's incapacity or death. Qualifications. Article 58 and 59 of the Constitution of India lay down the qualifications of the office of the President of India. The candidate for the office of President should be a citizen of India, must have completed 35 years of age and possesses other qualifications which are necessary to become a member of Lok Sabha. Methods of election. The Constitution prescribes an indirect election through an electoral college on the basis of proportional representation and by means of single transferable vote. To ensure uniformity among states, the value of the votes of elected members of the state assemblies is calculated on the basis of total population of the state. Voting is by single transferable vote, with electors casting first and second preferences. A candidate who receives an absolute majority of votes cast by the Electoral College is declared the winner. In case no candidate secure absolute majority in the first counting, the second preference votes of the lowest polling candidate are preferred to the other remaining candidates until such time as one candidate crosses the threshold of 50% of vote cast. Term of office and removal of the President. The term of the office of President of India is 5 years. His tenure commences from the date on which he assumes office after taking an oath administered by the Chief Justice of India. Though the Constitution is silent, the President can seek a second term. The President remains in office until his successor enters office. Article 56 and 61 deal with the procedure for impeaching the President of India. In this regard, the Constitution lays down violation of the Constitution as the ground for removal. The process of impeachment can be initiated in either House of Parliament and must be passed by not less than 2/3 of the total membership of the House in which it has been moved. Next topic is Powers of the President. Article 53 deals with the executive powers of the President of India. The powers of the President are broadly divided into two types, namely ordinary and emergency powers. The executive powers of the Union are vested in the President. Article 53 vests all executive powers in him and empower him to exercise these powers directly by himself or through officers subordinated to him. The President has both administrative and military powers. The President has the power of appointment and removal of high dignitaries of the states. The President appoints the Prime Minister and, on the later advice, the councils of ministers, the Attorney General, the Justice of Supreme Court and High Courts, member of special commissions and the governors of state. The President of India is also the Commander-in-Chief of the Defence Forces. He appoints the Chief of Army, the Navy and the Air Force. He has the power to declare war and conclude peace. The President can withhold or return a non-money bill for the reconsideration of the Parliament. Article 254 empowers the President to remove inconsistencies between laws passed by the Parliament and state legislature and the subject included in the concurrent list. The judicial powers of the President of India include the appointment of the Justice of Supreme Court and High Courts and the power to grant pardon, reprieve, suspension, remission and commutation of punishment or sentence of the court. Next topic is emergency power. The President is empowered to declare three types of emergency, namely national emergency arising out of war, external aggression or armed rebellion, emergency arising due to breakdown of the constitutional machinery in the states, and the financial emergency. The President can make a proclamation of national emergency at any time if he is satisfied that the security of Indian any part of the country is threatened by war, external aggression or armed rebellion. The proclamation must be submitted to the Parliament for its consideration and approval. If the Parliament fails to approve the proclamation bill, it ceases to operate. On 26 June 1975, for the first time, the President proclaimed on the advice of Prime Minister, emergency in the name of grave danger to internal security. When there is a breakdown of the constitutional machinery in the state, the President can impose emergency in the state. By the 44th Amendment, the Parliament can extend the duration of the state emergency for the period of 6 months at one instance. The President can impose financial emergency. Article 360 states that if the President is satisfied that a situation has arisen where the financial stability or credit of India or any part of the country is threatened, he can declare financial emergency. Coming towards the next topic, that is the Prime Minister. The real executive power under Constitution vested with the Union Council of Ministers, with the Prime Minister at its head. The President is obliged to act according to the advice of councils of ministers, which is responsible in the real sense of the term, not to the President but to the Lok Sabha. The Prime Minister is appointed by the President. The President appoints the other member of the Council of Ministers on the advice of Prime Minister. A minister may be chosen from either house and has a right to speak and take part in the proceedings of the other house, though he can vote only in the house to which he belongs. The councils of ministers and the cabinet. The term cabinet is used interchangeably with that of councils of minister, but they are different. The council of minister or the ministry consists of different categories of minister. At the time of independence, there was no such institution as a cabinet in India. The cabinet composed of the senior most ministers whose responsibility transcended departmental boundaries into the entire field of administration is a smaller body and the most powerful body in the government. The cabinet serves three major functions. It is the body which determines government policy for presentation of the parliament. It is responsible for implementing government policies. It carries out interdepartmental coordination and cooperation. Next in rank are the ministers of state who hold independent charge of individual minister and perform the same functions and exercise the same powers as a cabinet minister. The only difference between such a minister of state and a cabinet minister is that he or she is not a member of cabinet but attends cabinet meetings only when specially invited to do so in connection with the subject that he or she is given charge of. At the bottom of the hierarchy are the deputy ministers who do not have specific administrative responsibilities, but their duties include: number 1, answering of question in parliament on behalf of the ministers concerned and helping to pilot bills, explaining policies and programs to the general public and maintaining liaison with members of parliament, political parties and the press. And the last is undertaking special study or investigation of particular problems which may be assigned to them by particular minister. Next are the collective responsibility. The Council of Ministers function on the principle of collective responsibility. Doubts and disagreements are confined to the privacy of the cabinet room. Once a decision has been taken, it has to be loyally supported and considered as the decision of whole government. Unity within Council of Ministers is not only essential for its very survival, but is also necessary for its efficiency and efficacy, on the basis of which alone can it continue to enjoy the confidence of the people. Next is the cabinet and the parliament. The core of the parliamentary government is the accountability of Prime Minister and the cabinet of parliament. The parliament does not govern but critically examines the policies and acts of the government and approves or disapproves of them as the representative of the people. The general feeling is that the parliament controls the executive, but is rarely the Prime Minister with his majority supports control the very working of the parliament. Next are the sources of Prime Minister power and influence. The Prime Minister's prerogative of constituting, reconstituting and reshuffling the ministry as well as chairing the meeting bestows the office with considerable influence over the members of parliament. The Prime Minister's freedom to select his colleagues is subjected to his or her own position within the party. Emerging as an all-powerful leader after the 1971 midterm elections, she had completed freedom in choosing and reshuffling ministers. Next are the sources of Prime Minister's power and influence. The Prime Minister also derive powers and influence from the fact that he or she is the leader of the majority party and sometimes even the leader of parliamentary wing of the party. The Prime Minister advised the President on summoning the prorogation of the session of Parliament. The Speaker consults the Prime Minister in finalizing the agenda of the Lok Sabha. The Prime Minister enjoys enormous legislative power in the form of recommending ordinance to the President of promulgation when the Parliament is not in session. The Prime Minister's control over the administration, including the intelligence agency and other administrative wing of the government, enhances his or her influence over other members of parliament and administration. Next topic is the President and the Prime Minister. President is a constitutional head performing a ceremonial role. The first President of India, Dr. Rajendra Prasad, tried to break down the British convention that the head of the state is always bound by the advice of the Prime Minister and the Cabinet. In the 1960s, the theory of independent presidency gained some ground. K.M. Munshi, who developed the theory, argued that there is no provision in the Constitution of India which expressly laid down that the President is bound by the advice of the Council of Ministers. That's all for the session, and these are the questions which are based on the session. Question number 1. Define sources of Prime Minister's power and influence. And question number 2 is define the term cabinet. Thank you. Happy learning. We learning.